Hello, and welcome to our training on the role of behavioral health professionals and social service providers in petitioning as part of understanding the CARE Act process. Let's go over our overall agenda today. So today we're going to be talking about the CARE Act, and the first section will be providing an overview of CARE, describing the purpose of CARE, including who it helps and why it was created, and then an overview of the CARE process and eligibility and the petitioning process as part of CARE. And then the second half will focus on tips for documentation as you, an individual who might be completing some required documentation to start this CARE Act process, helping you understand what your role is in that and what you could include in that documentation. Our goal is that by the end of this session, you would have an increased ability to understand the unique aspects of care, including the different paths through the care process, understand the petitioning process and referring to care as a behavioral health or social service provider, and then use some best practices when interacting with the care population, including embracing a trauma-informed approach. So, as part of today's discussion, I'm going to be joined by my colleague, Laura Collins, who is a licensed clinical social worker with Health Management Associates and has 25 years of experience in psychiatry and across the behavioral health continuum, and has been working to help counties implement care and share best practices as counties figure out how to implement this process and help other stakeholders understand their role in the process as well.
Hi there. We have an important update regarding the CARE Act beginning January 1st, 2026. Changes made by Senate Bill 27 will go into effect. These changes include bipolar 1 disorder with psychotic features will now be included as an eligible diagnosis under the CARE Act, except psychosis related solely to intoxication. This law now defines what it means to be clinically stabilized and ongoing voluntary treatment. Certain court referrals can now serve as a care petition. Courts may consider care referrals earlier for individuals found incompetent to stand trial in misdemeanor cases. Nurse practitioners and physician's assistants are now authorized to complete affidavits in support of care petitions, and there are also some technical amendments to streamline the care process. Our training PDFs, including the notes, have been updated to reflect these changes, including the addition of bipolar 1 disorder with psychotic features, and they are available on the CARE Act Resource Center. But during this training video, you may hear older references to schizophrenia and other psychotic disorders, so keep this update in mind that it will now include bipolar 1 disorder with psychotic features starting January 1st, 2026, and other updates made by Senate Bill 27. Thank you for staying informed, and please review the updated resources linked in your training materials. You can find more information about these changes in our SB 27 brief on the CARE Act Resource Center, or email us at info@careact.org.
As we start this overview of CARE, we'll first, like I said, hit the overview CARE Act at a glance. So, what is the CARE Act? So, the CARE Act creates a new pathway to deliver mental health and substance use disorder services to a subset of Californians with the most complex behavioral health conditions who too often suffer in homelessness or incarceration without treatment. But care is more than just a process. It's about connecting individuals to services in their communities. So there are different paths into care and there are individualized paths out. But the thing to remember is that each path begins when someone files a petition, which just means that the petitioner or you believes that someone is eligible and would benefit from additional support. The goal is to give personalized support that someone would benefit from. So think about how health and social services providers could help an individual get on that path to receive help. So throughout this training, you'll see links on the screen, and these provide additional information. So in the training materials, you'll see all the talking points, additional considerations, and then also links to information if you're looking for more. So many behavioral health and social service providers have a similar question, which is how can care help? Why would I want to connect an individual through services and support through care? Now, there are The CARE process aims to serve as an upstream intervention and support for individuals with schizophrenia spectrum and other psychotic disorders, which can prevent hospitalizations, incarcerations, or conservatorships. So you see here, and in the material notes, there are more information about each of these, but the CARE Act really can offer additional services to an individual with schizophrenia who may need additional services and supports. So, Laura, as you look at this list, what's something you would call out as a way that CARE can help?
Well, I think one of the biggest components, the most important components of what differentiates CARE Act is that outreach and engagement piece, the front end work that happens with CARE in engaging these folks, identifying, outreaching, and engaging these individuals, building that trust, and doing it in a trauma-informed way. And peers are also a very large component of the work in that front end outreach and engagement. Those are some areas I'd like to highlight for sure.
Thanks, Laura. So you see other components of how CARE can help. Again, we talk about each of these in the meeting materials. Laura just mentioned outreach and engagement, and also peer support. It's also hopefully a less restrictive alternative to conservatorship, somebody who needs services and supports, but an intervention before, or maybe to help somebody step down from a conservatorship. So let's look at some CARE eligibility criteria. So here are the criteria. The CARE Act has specific eligibility, and we have that list here. And while it's good to have the eligibility criteria in mind, especially as a behavioral health or social service provider, you as the petitioner isn't responsible for proving a diagnosis. Rather, you should focus on documenting what you observe of someone and consider how they might benefit from care. And in the second half, Laura is going to go through and provide some tips and documentation from providers to help understand how they can speak to eligibility, and we'll go through each of those eligibility criteria. But again, it's here for you, and in the meeting materials, we link to different resources to understand that eligibility if you want to have a deeper understanding into who is eligible for care. So now we're going to turn to some eligible diagnoses. And Laura, can you speak to the eligible diagnoses for care?
Absolutely. It's very important when you are thinking about eligibility to sort of start with the qualifying diagnoses. And so this slide shows the array of diagnoses that are eligible, and specifically the schizophrenia spectrum and other psychotic disorders grouping. As defined in the Diagnostic and Statistical Manual of Mental Disorders, or also known as the DSM-5. That really defines in one chapter this grouping of diagnoses that essentially have psychotic features to them. Each of the diagnoses that you're seeing on the slides, though, does have some different diagnostic criteria. And also just noting on the slide that not all the diagnoses in this chapter of the DSM-5 are eligible for care. The two that are called out in pink that are not eligible are psychotic disorder due to a general medical condition or catatonia associated with a medical condition. Those diagnoses need to be accompanied with another eligible diagnosis to meet that care criteria. And then there are some other conditions that I want to call out that someone may experience psychosis with that aren't called out as an eligible diagnosis. And those are mood disorders with psychotic features, such as bipolar disorder or depression, major depression with psychosis. So even though they feature psychotic symptoms, they're not currently eligible diagnoses. And it's also important to note that substance use disorder as a standalone would also not be eligible, but it can be a co-occurring disorder with an eligible diagnosis. And then the other thing to keep in mind, and we'll get to this later, is that some of these eligible diagnoses may be they may be called out as eligible, but they'd still have to meet the other eligibility criteria, such as, one diagnosis that may not meet the other eligibility criteria is brief psychotic disorder or schizophreniform disorder, substance-induced psychotic disorder. These disorders tend to be brief in duration, and that's when we discuss the other eligibility criteria. That person may not meet the full scope of eligibility. And
Thanks.
then, yeah, let's go back to you, Patricia, and talk a little bit about those different options with petitioning versus referring.
Yeah. So, when you're thinking about filling out a petition, the petitioner can consider who is in the best position to file and if there's a way to collaborate to meet that goal. So, health and social service providers may be eligible to complete the petition themselves, but they can also be a referral source. So, as the petitioner, you would identify the court accepting petitions, and this could be listed on your county's care website, or you could search for the court on your county's court website. Then you would fill out the forms either electronically or physically. And again, you would focus on what you know, and you would document observed behaviors and why you believe the respondent may fit in that disorder class. And then you would fill out the petition according to your county's process. But note that there are no filing fees for care, and this can be done either in person or electronically or via mail, and that would be included on your county's court website for care. And then the petitioner would plan on attending the initial appearance. So this is the first time that the individual would appear in court or their public defender. And the petitioner is asked to appear as well. So we recommend that the petitioner reach out to County Behavioral Health to coordinate, as County Behavioral Health will step in as the petitioner at this initial appearance. So that's as the petitioner. You can also be a referral source. So you may choose to refer to County Behavioral Health or other eligible petitioners who may be more familiar or better positioned to petition. And then you would share information as appropriate to support their petition. So if you're part of an organization, it may be helpful to identify a liaison from your organization to support that connection. So let's take a look at what is actually asked for in the petition. So you see here a couple of different options, and we'll talk through which one you may be asked to participate in or complete yourself as a behavioral health professional. So keep in mind, the purpose of the petition is not to prove everything up front, but to give the judge enough information to decide whether the case should move forward. Based on what's submitted in the petition, the judge may either dismiss the petition or ask County Behavioral Health Agency to investigate further. So the petition doesn't need to be exhaustive, but again, just to include what you've observed and enough to reasonably believe the person may meet the eligibility criteria. So there are two main ways that you see on here to file a petition, depending on who you are and what information you have. We'll go over the different components of the petition. But here are the two options. So you see option one at the top. So this is the general petition process, which would apply for most petitioners. So you would use this path if you're not a licensed behavioral health professional, for example, family members or first responders. So these petitioners would fill out the Care 100 form, which allows the petitioner to explain observations in their own words. The step two is something that you might be a participant in for an individual completing a 100. And that's because one of the options to support a Care 100 form is a declaration from a licensed behavioral health professional who has either examined the person in the last 60 days or who has attempted to do that multiple times. And they must believe the person may meet eligibility criteria. So if there's a family member completing a Care 100 form or another eligible petitioner, you may be asked to support that petition with a Care 100 form. And then you would document eligibility, which again, we'll discuss in a moment. The petitioner has another option to include declaration or evidence to support their petition, and that would be evidence that the person has had at least 2 intensive treatments, one within the last 60 days. But note this is not an eligibility criteria, but just one of 2 possible ways to support a Care 100 form. So that's how you would participate as a licensed behavioral health professional, submitting a Care 100 form to support another petitioner's Care 100. So let's now look at option 2. So option 2 is a streamlined process for licensed behavioral health professionals. So you would use this a path if you're a licensed behavioral health professional, and it just provides a more streamlined way of doing that. You would fill out one form, or the Care 102 form, and this combines some of the information that's requested in option 1. And like the Care 100 or the Care 101, it allows you to describe what you observed and why you believe the person may be eligible for care. As a behavioral health and social service provider, it's important to understand that petition is not a test about getting it right or wrong. It's about providing what you observe and know and documenting this information in response to the questions. You only need to have a reasonable belief that the individual qualifies for care, and the judge has broad discretion when reviewing the petition and conducting an initial review. For more information or access to the forms, again, you see a couple links on this slide. You can access them in the meeting material notes, including looking at what those actual forms look like. Now, the CARE Act has some guidance for who can file a petition. So health and social service providers are among eligible petitioners. So there are a couple things to keep in mind here. So the director of a public or charitable organization, agency, or home, or a licensed behavioral health professional. But note that there are some requirements about when the eligible petitioner has seen the individual. For example, within 30 days has provided behavioral health services to a respondent, or where the respondent resides, or for a licensed behavioral health professional currently or in the previous 30 days have been involved in the respondent's treatment. So note that for the licensed behavioral health professional could include a psychologist, a clinical social worker, a professional clinical counselor, a marriage and family therapist, or a physician. And again, including documentation or observations of what you've observed with this individual. So both of these petitioner types include a designee. So this just means an individual at the organization who's been identified by the director to complete a petition. So the designee of a director of a charitable organization or home, for example, could include a social worker who's on staff and works with the respondent. Keep in mind that petitioners can again partner with other eligible petitioners to complete the petition. For example, if a first responder is completing the petition, a licensed behavioral health professional could help complete additional documentation, like we talked about with that Care 101 form. So for more information on and additional details, such as the timing which we discussed, we have a couple links on the slide for you to take a look at. So we just wanted to provide some additional information. Again, in the notes, there's more information for you to consult and look at and consider your role in completing a petition. And we'll go over some high-level information. So if you're a behavioral health professional, here are some things to keep in mind. So consider which existing information is relevant to the petition. You may have information about a diagnosis, or treatment history, including their medication adherence or hospitalization, and different supports that they have accessed. You might want to include that. When completing the petition, you can look at historical information in the individual's chart and provide that information and expedite confirmation of eligibility for care supports. It's also important to consider how to navigate confidentiality. You can provide this information in the petition, but many behavioral health providers choose to engage their own counsel to develop policies and procedures regarding how to navigate and share this information for the purpose of care and submitting a petition. And then again, evaluate whether you may be able to collaborate with the individual in the petitioning process. So if you are a treating provider, you may wish to approach the individual, explain the benefits of the care process to the individual, and complete parts of the petitioning process together. So in other cases, the individual may be experiencing significant mental health symptoms that participation in this process isn't possible. But as much as possible, you want to maintain or strengthen that therapeutic relationship throughout the care petitioning and referral process. So let's take a look at how individuals that are part of adult protective services could act as petitioner. Again, in many cases, APS professionals will have critical information regarding the acuity of needs that the individual is experiencing. So include as much relevant information as possible. So this could be a history of reports involving these individuals, information regarding threats to the safety, engagement attempts, or current concerns about safety. So again, it's also important to ensure that APS providers engage all possible supports to ensure that the individual's safety while eligibility is being determined. So, the court moves expeditiously to review these and engage with county behavioral health, but care is not an emergency service. It's a way to connect individuals with long-term support. So if there's a current concern about immediate safety, you should look to provide that immediate support for an individual as well, while the court process proceeds. So housing providers are also petitioners. So some things that you might have if, as a housing provider, somebody works with a housing provider, is housing history, including evidence of housing instability, any concerning behaviors that you've noticed that have maybe impacted the individual's ability to maintain safe housing or access self-care activities, any treatment history and engagement if you have it, and any supports that you think has been effective or could help them stabilize and continue in their recovery journey. And any attempt to continue to engage the individual in housing and behavioral health supports while eligibility is being determined is also important to continue promoting their safety. So those are the different ways that you could that you might be an eligible petitioner, again, as a behavioral health provider, as a social service provider, or a housing provider, and how you may contribute to completing a petition. So let's look at your role after the petition is filed. So the original petitioner will be provided notice of an initial appearance. And you should plan on being present, and you are able to make a statement at that initial appearance. Many courts are allowing remote appearances. So if you get that notice, you can coordinate with your court or maybe county behavioral health on if that is an option in your county, joining that appearance remotely. During the initial appearance, the court will replace the original petitioner, including health and social service providers, with county behavioral health, who will from then on be considered the petitioner. That is most likely where your role as a petitioner will end. There is some ability for petitioners to be included moving forward, and that will be determined by the court and with the individual respondent or the client's approval that they be included. So, we've just talked about the petitioning process, how you could contribute. One important component is incorporating a trauma-informed approach. And I'll invite my colleague to speak in a moment, but speak to how we can incorporate a trauma-informed approach. But here's some ideas. And again, in the training material notes, you see more information about how you can incorporate a trauma-informed approach into this petition process. And a trauma-informed approach ensures that the patient's past experiences with trauma are acknowledged and respected, reducing the risk of re-traumatization, which can enhance their engagement in the process and engage them in services and supports and a treatment plan that will help them in their recovery. So we include some tips here for you to consider as you take a trauma-informed approach to the petitioning process, but understanding the patient's history, reviewing their medical and social history to understand how the history of trauma may impact their current state or their receptiveness to being engaged in care. Provide clear and compassionate communication involving the patient in decision making wherever possible, ensuring safety and trust, and including, creating a safe environment to discuss with the individual, building trust with that patient, minimizing that re-traumatization, and practicing cultural humility. So again, we have more notes here. Laura, as as a behavioral health professional yourself, somebody who's worked with individuals through similar court processes, what advice would you have for how to take a trauma-informed approach to the petitioning process?
It's a great question. And I think the first thing that comes to mind is transparency. It really kind of hits a couple of those bullets in terms of clear, compassionate communication and including the patient in the decision making. So being really clear that, kind of the why behind the petition in the first place, that this is about the fact that you're hoping to help them gain access to services and supports and potential housing and really support their goals in in their for their own stability. So I think and also keeping in mind all the other areas that you spoke about, Patricia, around just knowing their history and how to have that conversation is really important as well. So it's very individualized, but I think the key is that kind of authenticity and transparency and humility around communicating the process and being as clear as possible.
Thanks, Laura. And again, if you want to have some more ideas or some considerations on taking this trauma-informed approach, we include some examples in the meeting materials for you to consider how you can incorporate that. So to wrap up this first section, Laura, what should clinicians consider as they're preparing to complete a petition?
Well, thinking about what you've kind of covered, what we've covered so far, just really ensuring that the clinician is familiarized with all the eligibility criteria as much as possible. They don't have to be experts. Knowing that what those diagnoses are that are qualifying, but not feeling like they have to know every detail, and just having that reasonable belief that the individual might qualify. Collaboration is key when you are completing the petition. Just think about other providers that may be able to support that process, family members that can help inform and bolster the petition, and that ties into documentation. You may have access to good information that you can pull right into the petition. We've heard about providers that are able to copy from pull information straight from the medical record for efficiency's sake, that has the right information in there. And then remember, if you don't have the information, you can always document your observations. And we're going to talk a little bit more about some of the detail that we would want to put in that petition in a minute. But those nonverbals, documenting the behaviors, it's all very helpful in terms of bolstering the petition. And then kind of like what we just talked about when Patricia asked me about trauma-informed approach is, again, it's really just want to kind of reiterate, it's really important to talk to the individual themselves, the potential respondent, of why you are referring them to care. And all the things that you're hoping to help them access. And again, thinking about who could also participate in that discussion with you, and the potential respondent who might be, helpful in having that important conversation, critical conversation.
Thanks, Laura. And we've used the term respondent a few times. As a behavioral health professional, you know them as a patient or a client. And in a legal process, they would be known as the respondent. County behavioral health teams see them in a similar way as you likely do, which is a patient or a client that they are working to support. But if you hear the word respondent, it just means they're involved in that civil court process that's connecting them to services and holding the county responsible for providing those services. So, Laura, you mentioned tips for documentation. We went over the eligibility requirements, but in the second section of the training, we'll learn more about some tips for documentation that health and social providers can consider as they complete a petition or share information with other eligible petitioners to submit their submission. So, Laura, I was wondering if you could share some key tips for what these individuals may consider as they're beginning to think about, again, completing that petition or participating in somebody else's petition.
Yes, it's always good to start with kind of some key tips, key reminders, before we delve into some of the elements of documentation. So first off, you want to reach out to the person or people that are identified as your county's care contacts. And just ask, about that, what the role is for the initial petitioner as that court process initiates. And then when you do petition, just again, remember, this is getting in a little bit into the documentation. Document those objective and specific observations. Try to avoid bias. It's hard, but kind of check your bias when you're documenting. Again, just what do you see, and use those objective terms versus subjective terms. And just remember to always include any statements, quotes from the individual that you are petitioning on. Those are very powerful, what they say, and just documenting that. And then also thinking about those efficiencies that I mentioned earlier, pulling from the electronic health record to help populate the forms. It's really good information, and it's already there. So if that's a possibility for your organization, think about pulling from the EHR. And then just another reminder, we've already mentioned it, but you really only need to file if you have just a reason to believe the person may be eligible. You don't have to be 100% convinced that the diagnosis is correct, or that they meet all those eligibility criteria that we're about to walk through.
Thanks. So, we've talked about the petition. Laura, can you speak to some of the components that a behavioral health provider or a social service provider would encounter in these care petition forms?
Absolutely. So regardless of the form you use, the petition itself will ask for information about the petitioner. It'll ask for information about the respondent, how to contact them, language or accessibility accommodations they may need, and information about a court referral, if that's part of this, if the referral is being made from a court in this case. But the bulk of the questions on the forms are going to focus on capturing information related to the individual's potential eligibility for care. So the purpose of the petition is not to prove everything up front. Just again, give the judge enough information to decide whether the case should move forward. Based on what's submitted, the judge may either dismiss the petition or ask the county behavioral health agency to investigate further. And so this means the petition doesn't need to be exhaustive. It should include the information that you have, what you know, what you have observed, enough to reasonably believe that the person may meet care criteria. So let's look at each of these. So as the petitioner, you'll be asked to provide your name and contact information. You'll also need to describe your interactions with the respondent. And as a licensed behavioral health professional, you'll be asked to provide information on your credentials, timing of treatment, and your last examination or attempts to examine, and your basis for opinions stated in the petition. And then let's go to the respondent information. So you'll be asked for information about the respondent. You may not have all the information, but provide what you can and what you think would be helpful, especially in locating the individual. So contact information could include the name and age, or approximate name and age, or approximate age is fine. Where they live or where you think they can be found. Information how to contact them. Again, any language or accessibility needs. Do they need help reading, hearing, understanding English? And additional information that could be asked depending on the form. A disability that's requiring accommodation, maybe interpreter, although that's not a disability, but anything requiring accommodation. If the respondent is a regional center client or former military, a member of an Indian tribe, or receiving services from a tribal health agency, information about involved juvenile courts jurisdiction, or about a court-ordered conservatorship. Again, you may not know all of this info, and it may not be relevant to the respondent, but just include what you know is applicable. And then let's go to the court referral information, again, if applicable. So you'll be asked to include this information if the petition is being filed in response to a referral from another court proceeding. So you'll need to note the referring court and case number, the type of proceeding. It could be from AOT, it could be from IST, and it could be from a LPS conservatorship court. You would need a copy of referral order, the respondent's attorney in the proceeding, and again, just include the information to the extent that you know it. All right, here we go to the evidence of potential eligibility. So again, most of these questions in the petition are meant to help the judge decide if the person meets or may meet eligibility. So I'm going to speak to each of these with some examples. As a behavioral health professional, you can provide additional clinical information. You could provide your insights and any details that'll help determine eligibility. And again, you don't need to provide exhaustive information, just enough for the judge to determine that the person may be eligible. And keep in mind with all of this that we're going to walk through that the respondent does receive a copy of the petition. So that, again, kind of coming back to when you're having that conversation with the respondent, when you are filing the petition, that they may be reading some information that can be sensitive or upsetting, and preparing them for that as much as possible. Let's go to the next slide. And moving to the section where we get into the clinical and functional criteria related to eligibility, starting with diagnosis. So again, eligible diagnosis for care include anything under the schizophrenia spectrum disorder or other psychotic disorder class. When you are noting the diagnosis on these forms, you may only have historical diagnostic information or even provisional or preliminary diagnostic information. So just note what you're aware of in terms of the individual's diagnosis or diagnoses, including if there's a co-occurring substance use disorder. And then if the diagnosis isn't known, document those observed behaviors. What do you see? What are they saying? What are they doing? What are they wearing? Where are they living? All the observations that may help the judge come to some conclusion that they may be eligible. So next, we're going to move to documentation that supports the individual's eligibility as having a serious mental disorder. There are three aspects to support this. So first, you'll need to address that the mental disorder is severe in degree and persistent in duration. This is where you speak specifically to the severity of the symptoms you're observing. So here are some examples of the symptoms on the slide. Speech and behaviors you may want to note, including how the illness may be impacting the individual's insight and their judgment. So they may be responding to internal voices, audio hallucinations, there may be paranoia or other delusional beliefs or statements they're making. Their speech may be disorganized or tangential. Their behavior may be disorganized as well, or unsafe. Are they wandering into traffic? They may be behaving in an irritable or aggressive way. They may be isolative or seclusive. And again, they may be exhibiting what we call lack of insight or judgment into their illness or need for assistance. So with regards to mental disorder being persistent in duration, note how long the symptoms have been observed, and really if you have it, the knowledge of the initial date of diagnosis. And then we go to that second area that supports the assertion of serious mental disorder, that the individual's behavior is interfering with their activities of daily living, or we call them ADLs. Some key examples of how you might document this are noted here, related to self-care and day-to-day functional tasks. So that could include bathing and grooming. Are they disheveled? Are they malodorous? Some of those terms fit here. What are they wearing? Are they wearing many layers and it's 100 degrees outside, or it's cold outside and they have no socks? Is their weight loss significant? Do they have a visible medical condition? Do they have sores that are visible, that look infected? And then those day-to-day functional tasks. Are they able to access transportation, get food? Are they able to accept medical care? And then the third supporting assertion for serious mental disorder is that without treatment, support, and rehabilitation, the individual will not be able to maintain stability or independent functioning. So you'd want to consider their history of housing or housing instability, their social relationships, their functioning in the community. And this is a great opportunity to note your objective observations of their symptoms or behaviors that may be interfering with these things, with their safety, with their stability, and their overall functioning. So then we move to the additional requirements that are called out in the petition forms, starting with and even noting that the individuals currently enrolled in outpatient treatment, they aren't clinically stable. This is a really important call out. There are a lot of individuals that are in treatment, may be enrolled, but they're not either accessing services, or the services that they are accessing are not showing that, not contributing to their stability. So are they declining the mental health services even intermittently? Or even despite, like I said, participating in treatment, they're just not stabilizing. The next requirement really relates to your assessment of the individual's likelihood of surviving safely in the community without supervision. So this really includes documenting your observations, again, those observations of the individual's deteriorating condition. If you don't have information, or you don't have those observations regarding the individual's deterioration, you do have the option to note why you believe services and supports might prevent a relapse or a deterioration, which may lead to grave disability. It may lead to harm to self or others. So these are really important things to be aware of and document for additional eligibility components. All right, so the final pieces of information you'll need to document is that care is the least restrictive alternative of treatment options for the individual, and how care might help the individual with regards to their stabilization and their overall recovery. So this is where you would note what other treatments or programs haven't been successful, and provide recommendations for other models of care, or outpatient specific models of care. So for individuals who, again, may already be served in similar treatment models but haven't been stabilized, like we talked about earlier, just note your recommendations for how the CARE Act may enhance their care and include those recommendations for wraparound models of care, such as full service partnership, FSP, or assertive community treatment, or ACT. Remember that there are two options for completing the petition. Just coming back to this. So we've largely been talking about information that could be included in the CARE 100, the CARE 101, or the CARE 102 forms. Remember that the CARE 100 form should either be accompanied by a CARE 101, which will contain many of the details we've just discussed. If you're a licensed behavioral health professional, you may be asked to complete that CARE 101 form to support someone else's petition. Then if a CARE 101 is not available or not able to be completed, you can present alternative evidence that the respondent was detained for at least 2 14-day holds or hospitalizations, the most recent period within the last 60 days. So a CARE 100 form can either include that declaration in the CARE 100 itself, acknowledging that you have personal knowledge of these hospitalizations, or attach a document that provides this alternative evidence. And then what are examples of the evidence? So documented evidence from the facility where the respondent was detained, a copy of the certification of intensive treatment, hospital discharge paperwork, and then a signed declaration from the petitioner if they have personal knowledge of the detentions, or a signed declaration from a witness or someone that has personal knowledge of the detentions. So as a licensed behavioral health professional, you have the option to provide this alternative evidence of 2 5250s. That's a mouthful, of those 2 14-day holds, if they're available. But you're not required to provide this information in addition to the information you're providing on the 101 or 102. Again, the evidence of those 5250s is not an eligibility requirement for care. The individual may still be eligible for care even if they've not had those recent hospitalizations. But if you have knowledge of these hospitalizations, it really could help demonstrate eligibility, could bolster the petition. So it might be helpful to include that relevant information. So Patricia, I'm going to turn it to you with a question based on what we've talked about. So if you're encountering someone that you think may benefit from care, what approach might you take?
So just like you talked about, I would take some time to collect all relevant information that can support the petition and possible eligibility, reviewing clinical notes, conversations with other treatment providers or first responders or family members that may contribute to that petition, and see if that provides me some reasonable belief that someone may be eligible for care. I would also probably see if it would be appropriate to engage my patient or client directly and introduce them to the idea of care, see if they may be open to that engagement, and potentially even participatory in completing the care petition, letting them know what next steps would be and what my role would be as the petitioner in attempting to connect them with services and supports. So that's how I might take an approach I might take when encountering somebody who may benefit. And you can also think of different ways that you might approach someone or someone that you're aware of that could benefit from additional services and supports available through this civil court process and connection to county behavioral health. So thank you, Laura, for that discussion. Again, our goal is that by the end of this training, you will have had an increased ability to do a few things. First is understand those unique aspects of care, including those different paths through care, and then understanding the petitioning and referring someone to care as a health or social service provider, and then again understanding and exploring some best practices when interacting with this care population and using some of those trauma-informed approaches that we discussed and that you use in your practice as well. So we do have some additional resource centers. So on our CARE Act Resource Center, we have a number of resources for those involved in CARE Act implementation. For you as a petitioner, we have a few trainings and resources called out. We have resources for petitioners. This is a landing page which consolidates some useful tutorials, information for different petitioner groups. So you're likely behavioral health or social service provider. We also have trainings for first responders, for those at a facility, and for public guardian or conservators to understand their role in petitioners. So those are also on that landing page. We also have a training and resource library that has a number of trainings related to the CARE Act if you want to better understand the care process. We have a number of trainings on how to take a trauma-informed approach as well. One resources I wanted to point out is our county directory. So we have, this is a county specific process. You'll need to file the petition with the court in your county or where the individual resides or is located or is receiving services. You can find that court on our county directory. And we also list some contacts for the county behavioral health agency as well. So if you're wondering where to go next, you think that care might be a good option and you want to take the next step, you can go to that county directory and find the court accepting care petitions in your county. And there are a number of ways to stay connected. So if you want to continue to get updates related to the CARE Act, you can join our listserv, request technical assistance, and when all else fails, we have an email address, so there really is a no wrong door. So a few of those trainings, again, we mentioned taking a trauma-informed approach. We have a number of trainings, including those specific for behavioral health providers or county behavioral health as well, and also a series of trainings for volunteer supporters or more of a lay audience on how to take a trauma-informed approach to the care process. Laura also mentioned setting aside your bias as much as possible, and we do have a training on how to mitigate implicit bias and specifically how you can integrate that into care. So those are available as well. We also have a training on psychiatric advance directives, what a PAD is, and how you could potentially use it. It goes over some tips for some first responders, but also can have some tips for you as a behavioral health professional, even outside of care if you wanted to engage one of your clients or patients in developing a psychiatric advance directive to participate in their care and treatment plan. You can view that training. And again, it's specific to care, but also provides a lot of examples and some instruction for you, even outside of care, if you want to work with one of your patients to develop a psychiatric advance directive. And like I mentioned, we have a number of resources and trainings, including some high-level overviews, again, if you want to just have a high-level understanding of care or the care process. And resources, fact sheets, toolkits, FAQs, and recordings and trainings, decks that have the talking points and the links that you can click on to go for more information. We do have a no wrong door approach. So if you have a question, but you aren't sure where to find the information, we do monitor the info@careact.org web email address and connect you to resources or individuals. So if you need help tracking down the court website in your county or understanding how to complete a petition form, you're welcome to reach out to that email address and we'll get back to you with information or resources or other training and technical assistance as appropriate. So thank you again, and please reach out if you have any questions.